Hi friends, welcome back to Jury and Justice. Shruti Desai's lecture on law. We are learning RERA. Before starting with today's lecture on RERA, I request all of you to subscribe for this channel and also click on the bell icon. It is free, and if you want to know more about me, do visit my website www.shrutidesai.in/. Last occasion we stopped at this state of Maharashtra circular clarifying the jurisdiction of the dispute regarding execution of conveyance. It is only pertaining to state of Maharashtra and not entire India. I clarify for benefit, and the clarification question was asked to me, so beforehand I am clarifying that circular only pertains to state of Maharashtra. Now going further, let us see what is the next definition in the act. Next definition is ZB. It is defining the term internal development works. It means it defines the internal development work, roads, footpaths, water supply, sewer, drains, parks, tree planting, street lighting, provision for community buildings, and for treatment and disposal of sewage and sewage water, solid waste management and disposal water conservation, energy management, fire protection and fire safety requirements, social infrastructure such as educational, health and other public amenities, or any other work in a project for its benefit as per the sanction plan. So even such facilities is always described in the plan. Now there was a case in Supreme Court where the question arises that community facilities and amenities are part of development work or not. In DLF Kutub Enclave Complex Education and Charitable Trust versus State of Haryana, it is a judgment of 2003 passed by Apex Court, and it is held that community facilities and amenities are not part of development work under the Development Act, which is in force in state of Haryana. But now this definition is in force in entire India. So internal development work is now uniform and applicable to entire India. If there is any conflict between the two, the RERA definition would prevail over the local act definition. Because there is a provision under the act, we will come to that later on, but then I am just informing you that there is a provision in the act that act supersedes all other acts and provisions. Now in Ansal Properties and Industries Limited versus State of Haryana, this is also a judgment of Supreme Court in 2009, and issue is non-development of community buildings. In that, court held that since land has been given free of cost, now see the argument of the state of Haryana that I have given you free of cost land, so whatever you have constructed on my land, you should give me free of cost. So now let us see what Supreme Court held. It says that since the land has been given free of cost, it is now now open to the government to get the remaining community buildings constructed either by themselves or through any other agency or institution or individual at its cost in terms of provisions of the Act, in which case the terms and conditions could be laid down by the government for such community buildings to be constructed on the land which is transferred to it by the appellant free of cost. The government cannot in law demand that the buildings on the said lands which is to be transferred to them free of cost should also be constructed by the appellant and then transfer the land to them free of cost along with the construction thereon, and on failure to construct to pay for the cost of construction. That would be the in fact be a case of an illegal and unauthorized demand, as it has no statutory mandate. So this is it was held that this demand by the state of Haryana was illegal. This is in 2009. It was held the respondent, that is state, cannot demand transfer on the land free of cost, and also the construction cost of the facilities to be provided in the said land. So this was in unsold properties. Now there is yet another judgment of the Supreme Court in DLF versus Manmohan. It is of 2014, and it is held in this that the colonizer cannot recover cost of land or amount spent by him for providing facilities from the apartment owner. It is for that reason that clause 7 of section 3F of Apartment Act, as applicable in state of Haryana, has not made it obligatory on the part of the colonizer to include community and commercial facilities in its declaration. So now let us read the judgment portion of it. I will read the extract of this judgment. It says that the right to enjoy the facilities, that is the common facilities, as described in Development Act, whether shown in the declaration or not. That is, in apartment we execute declaration, in societies we execute conveyance. So here it is an apartment, so they talk about declaration, that is a sort of a conveyance. It is a different type of a conveyance. So cannot be restricted or curtailed, and apartment owners have no other right except right to user. Community centers, nursery schools, shops, etc., therefore being part of the approved layout plan by DTCP, can be used by the apartment owners, and being the part of larger colony, are intended for independent use of all the apartment owners, having direct exit to the common areas, to the public street, road, etc. All those facts would indicate, so far as apartment owners are concerned, they have only a right of user. So far as the facilities provided under Development Act of the what is mentioned in the clauses of the agreement would indicate that the ownership of the portion of the land set apart for the common areas and facilities referred to therein vests with the colonizer, so also the obligation at his own cost to provide those facilities in the land set apart for the said purpose. So it says that apartment owners are only entitled to declaration in respect of their apartment and the lands on which the building standing thereon. All other common amenities and facilities belong to the developer. Now, sorry. The next definition is of local authority, that is ZC. It means, it is defined in the Act as, it means the corporation, municipal corporation or municipal panchayat or municipality or any other local body constituted under any law for the time being in force for providing municipal services, for basic services as the case may be, in respect of the areas under its jurisdiction. It doesn't require much of explanation. There is a next definition is of ZD, of member, and it means the member of real estate regulatory authority appointed under section 21 and includes chairman. ZE is the definition of notification, and it means a notification published in the official gazette, and the expression notify shall be construed accordingly. Next definition is of occupancy certificate, that is ZF, and it means the occupation certificate or such other certificate by whatever name called. I mean, every corporation or panchayat may have some different name, but the nature of its enforcement is the same. So whatever name called, that is that word is used, issued by the competent authority permitting occupation of any building as provided under local laws which has provision for civic infrastructure such as water, sanitation and electricity, whether the competent authority was not duty bound to examine. Now we are learning something more about it. So what we learn, as provided under the local laws which has provisions for civic infrastructure such as water, sanitation and electricity. So this is the definition. Now let us see whether the competent authority was not duty bound to examine the terms and conditions of memorandum of understanding before granting occupation certificate to the claimant respondent, giving rise to a protected litigation. This issue came. So can this authority check the memorandum and articles or understanding between the parties? The answer was in negative. This is All Maharashtra BCI 2013 and 14 judgment of Chanda C. Kadam versus Additional Collector and Competent Authority, and it was held that although an administrative authority including municipal corporation, while granting occupation certificate after completion of the project, discharges administrative function and may not be duty bound to examine the title of the contesting parties, it is certainly expected to examine the documents of title or MOU while granting such certificate, especially when the matter is remitted to them for examining and the correctness and validity of such occupation certificate. In the process, it is surely not expected to adjudicate and determine the question of title of contesting parties. So it is not within their jurisdiction, but it is certainly obliged to form an opinion prima facie as to whether the occupation certificate is being granted to the rightful owner or not. Only for this purpose they can verify the MOU and other title documents. They cannot decide on title. If there is a dispute regarding title, it has to go to civil court, not even RERA court. So RERA court don't decide the title. RERA court only decides that there is an agreement, there is a money given, and he has not given the possession so on the date, and or there is a violation, there is an alteration without their permission. So in that case RERA can intervene, not otherwise. They have no jurisdiction to decide on title. Now next question is raised under this occupation certificate is whether building occupied. Building in Mumbai, there are many buildings where there is no occupation certificate, yet it is occupied. So whether building occupied without certificate liable for tax. Answering the query in affirmative, Supreme Court in Pradeep Oil Corporation versus Municipal Corporation of Delhi in 2011, it was held that the occupation of the building may be lawful or unlawful, even in a case where apartments are constructed on the land belonging to the government or a statutory body, but the occupier of the apartment is liable to pay tax. So even if you, there was when I was a junior at that time, there was a discussion whether the payment of tax makes your apartment legal, but answer is no. Payment of tax doesn't make your apartment or a building legal. It should be as per the sanction plan, and if it is not, it can be demolished at any point of time, even if after 100 years, if it is not in accordance and compliance with the plan sanctioned by the authority, it can be demolished, and you may get demolition notice also. So then nothing can save you. So do check when you buy the property properly. So even if you pay tax but your construction is illegal, it doesn't become legal by payment of tax. If a person, now it further goes and explains, if a person encroaches upon somebody's land and construct a building thereupon, he would also be liable to pay tax. Once it is held that the grantee were liable to pay tax, the same becomes payable from the date of accrual of the liability. The said position is also fortified from the specific stipulation in the agreement that the liability to pay all taxes, including municipal tax, is on the grantee. So be careful. You check the plan on the website wherever you are in India now. Whichever property you are buying, plan has to be there, and if it is not registered with the RERA, you don't buy. That is what is advisable, my advice. And see, if it is not registered yet they are collecting money from the public, inform your state government RERA authority, so they will take appropriate steps to stop it, because there is also penal provision in the RERA Act regarding penalty plus criminal. So if any promoter builder has not registered yet he is selling the property without registration, it's a crime. Now next definition is of person. It is an inclusive definition. It includes an individual, a Hindu undivided family, a company, a firm under the Partnership Act or limited liability LLPs, a competent authority, an association of persons or body of individual, whether incorporated or not, a cooperative society registered under any law relating to cooperative societies, any such other entity as the appropriate government may by notification specify in this behalf. So it's an inclusive definition. Now a question arose in the matter of Maria Fernandez versus Jack. It was it was before the Supreme Court in 2012. A servant in possession can be treated as owner. So it was held that a servant, though holding an object, holds it for its master, his master. He has therefore merely the custody of the thing and not possession, which would always be with the master. Though the master may not be in actual contact of the thing, it is in this light in which the concept of possession has to be understood in the context of servant and the master. So servant is a fictitious owner. He may be there, but the actual possession is always with the master. Now tomorrow let us complete planning area. The planning area is ZH, and it means a planning area or a development area or a local planning area or a regional development plan area by whatever name called, or any other area specified as such by the appropriate government or competent authority, and includes any area designated by the appropriate government or the competent authority to be planning area for future planned development under the law relating to town and country planning for the time being in force and as revised from time to time. Now there is a judgment, Isha Ekta Apartment versus Municipal Corporation of Mumbai. It is of 2013 and it is decided by the Supreme Court, and in which it is held that we would like to reiterate that no authority administering municipal laws and other similar laws can encourage violation of sanction plan. The courts are also expected to refrain from exercising equitable jurisdiction for regularization of illegal and unauthorized construction, else it would encourage violators of the planning law and destroy the very idea and concept of planned development of urban as well as rural areas. So this is what the Supreme Court has said. The next definition is of prescribed, and it means prescribed by the rules made under this act. Next definition is of project, and it means the real estate project as defined in clause ZN. Tomorrow we will learn about promoters. That is the next definition. We will stop here because there may be some judgments and rulings of Maharera also. Before parting, as we have said that we will learn every day, we will discuss about the provisions or the design of various states of RERA. Today we will see Rajasthan Real Regulatory Authority. It's a good website, but it appears that there is nothing much development project, and very few development judgments is there on the website. It is about us. It has home about us, online registration of real estate project and real estate agent. Then there is a search. It is project search. In project search there is a district. Option is district like Ajmer, Bhilwara, Nagpur, Nagar, Tong, Bharatpur, Dholpur, Karauli, Savai Madhopur, Bikaner, Churu, Hanumangarh, Sri Ganganagar, Alwar, Dausa, Jaipur, Junjunu, Sikar, and there is up to Udaipur it is. Then you have to put the promoter's name, project name and registration number. The only thing is if you don't know the promoter name or a project name, then there is no other option. You cannot have the search of project. So you must have, if you want to search here, you must have name of the promoter and project name. It is also there in the Maharashtra also, but then there should be some other advanced search engine also. That is because sometimes we don't know, and we just know the place where it is, and we try to search, we will not get. Grievance, complaint before RERA, the complaint name of the complainant, address of office of the residence of the complainant. That is the form they have given, and I feel this is a much better way to file a complaint. It is appealing. And then there is complaint before adjudicating officer, appeal to Rajasthan RERA. This is also form is good. Then there is cause list, and there is order. So this is what is provided. It is a good website. Then there is FAQ, general FAQ is given. Then downloads, there is an act, rules, notification, application forms, and contact us. They have given the addresses. There is also registration help. This is good. And the only thing is search engine, they should give more option for the search. It's a very good website. We'll stop here. Thank you very much. Stay tuned. I'll come back tomorrow once again with the definition of promoter. If you have any queries, do post me on my website www.shrutidesai.in/ or in comments below this video. I will always I will try to answer and satisfy your queries. Stay tuned.